May it please the Court, my name is Moorhead, M-O-O-R-H-E-A-D, initial M, and I appear on behalf of the applicant. Your Honour, I will begin by addressing Submission 1 and the outline of arguments. The applicant commenced employment in Queensland Mining in January of 2014 as mine manager. He is a National System employee as defined in Section 14 of the Fair Work Act, and he is covered by an award. He was placed on a 2-year contract with the company when he began his employment that expired in January of 2016. His employment with Queensland Mining continued past the expiry of that initial contract and continued until the time of his recent dismissal. His role with the company has not changed since the beginning of his employment, and he has always had the terms and conditions set out in his original contract. Your Honour, in Gerardo and Italian Assistants Association, it was said that an expectation of continuing employment by the employee, as in the present case, was enough to characterise the employment contract as indefinite in certain circumstances. We argue that such is the case here. Clause 11.3 of the applicant's employment contract with the respondent reads as follows. If an employee's performance does not meet agreed KPIs, their employment may be terminated after due counselling. The applicant in his evidence in chief says that at no time was an offer made by the respondent to himself to partake in the counselling process. Further, Your Honour, Clause 11.1 of the contract provides that the contract may only be terminated fairly or for good cause. Both of these clauses, Your Honour, have the design of affording the applicant natural justice, and both clauses have been breached by the respondent. Your Honour, the respondent in ground 3 of the letter of termination alleges that the applicant reached compulsory retirement age for an underground mine worker under the Act. Your Honour, the applicant's duties were primarily carried out in an office environment. He is only occasionally required to go underground for operational reasons. The Act defines an underground mine worker as a person who works on a regular basis in an underground coal mine. The Act, Your Honour, contemplates the onerous physical demands of the underground mining on persons over the age of 60. It is not intended to apply to a person simply because they find themselves at one time or another physically under the ground and in a coal mine. Further, dismissing the applicant because of his age, in the absence of any applicable legislation or agreement that might provide for such a dismissal, is a breach of Section 18 of the Age Discrimination Act 2004. Ground 4 of the respondent's letter of termination alleges that the applicant engaged in serious misconduct by his objections to employing lesser qualified workers and to achieving staffing cuts. As manager of the mine, the applicant has a duty of care to take reasonable precautions to ensure the safety of employees. This duty comes both from statute and at the common law. Section 27 of the Work Health and Safety Act 2011 obliges managers to exercise due diligence to ensure that a person conducting a business or undertaking, in this case the respondent, complies with the Act. Mr Grant was duty bound to raise concerns about the safety of the employees at the mine. It must also be remembered that Mr Grant at no time refused to comply outright with the directions of the company. Mr Grant states in his evidence in chief that he was not offered an opportunity to respond to the allegations or to access the grievance process. There was a clear requirement in Clause 11.1 of the Workplace Agreement to act fairly when terminating an employee. In McLear versus the University of Western Australia, Justice Siopis held that it is a fundamental element of procedural fairness that a party should know the case that has been made against him or her so that the person may have a fair opportunity to defend himself or herself. Mr Grant was not given this opportunity. Ground 5 in the letter of termination alleges that the applicant engaged in misconduct by discussing confidential information with the union. The applicant alerted the union to the fact that it was an intention to cut staff levels at the mine, but he did not discuss the number, where they would apply or when they would be introduced. The applicant had a duty of care to other workers in the mine. Section 27 of the Work Health and Safety Act 2011 says that the duty of an officer, such as Mr. Grant, of a business or undertaking is to exercise due diligence. Subsection 5E gives consulting with workers as an example of duties that form part of this due diligence. Therefore, the applicant as an officer of a company had a duty under the Act to inform the workers of what he perceived to be safety concerns. And the very existence of this duty makes the information divulged to the mine workers public in nature. It follows that, as held in Del Casal and Artidomus, this information being public in nature, the information cannot be classed as confidential at law. Two other considerations discussed in Del Casal and Artidomus are also relevant. The information was not commercially viable, nor did the respondent suffer any detriment. Mr. Grant was dismissed by text message while on annual leave and told that his employment was terminated on the preceding Friday. Section 117 of the Fair Work Act, subsection 1, provides that a notice be given before the date of dismissal. In addition, Your Honour, there is authority in LHMU and Cuddles Management that the notice period cannot coincide with the period of annual leave. Notice in the present case could not have started on the Friday as claimed by the respondent. The respondent may wish to raise as a defence to unfair dismissal the claim that the dismissal was a genuine redundancy as described under the Act. But importantly, the respondent did not consult with my client about workplace changes as required to under his award. This submission has ramifications under Section 385 of the Fair Work Act. No defence of redundancy will apply against an unfair dismissal claim if it is not a genuine redundancy as defined in the Fair Work Act. Because of the respondent's failure to consult on workplace changes as required under his award and as required in Section 389 of the Fair Work Act, the redundancy is not a genuine one as defined in the Act. These submissions argue that the dismissal was harsh, just and unreasonable because the applicant was denied natural justice and procedures required to be followed by the employment agreement, and who is also not guilty of any of the alleged misconduct. I turn now to submission 2. In Rankin and Marine International, the court agreed that a duty to provide reasonable notice was implied into employment contracts at common law, and that the primary purpose of the notice is to allow the employee sufficient time to find similar employment. In the case of Quinn and Jack Cheer Australia, factors said to be relevant considerations were a person's position, salary, age, qualifications, and what position the person left to come to be with the present employer. We note now, Your Honour, that Mr. Hughes left a comfortable and well-paying job to come to this employer. And Your Honour, considering the other factors and balancing these factors with particular awareness of Mr. Grant's age, his qualifications and his position, it is submitted that a period of 12 months' notice is reasonable. I now turn to submission 3. Your Honour, ground 1 of the letter of termination claims that the applicant's position no longer exists and will no longer be funded. This fits the definition of redundancy given in the TCR case, that is, a dismissal is a redundancy if it occurs not on account of any act or default of the employee, but because the employer no longer wishes the job the employee has been doing to be done by anyone. Your Honour, this is the end of our submissions. We seek the remedies set out in the applicant's outline of argument. Thank you, Your Honour.